Hello, Council. Today's topic is about the challenge and removal of arbitrators, an essential aspect of ensuring fairness and integrity in arbitration. In our last episode, we explored the importance of impartiality and independence in arbitrators. But what happens when these standards are compromised? That's where the process of challenging and potentially removing an arbitrator comes into play. Arbitration is designed to be a fair and efficient alternative to litigation. However, the process can be derailed if one of the arbitrators is perceived to be biased or not independent. The grounds for challenging an arbitrator are typically tied to the issues we discussed earlier in impartiality and independence. Under most arbitration rules, including the UNCITRAL arbitration rules and the rules of major arbitration institutions like the ICC or LCIA, a party can challenge an arbitrator if there are justifiable doubts about their impartiality or independence. This is not just a theoretical concern. Such doubts can arise from a variety of situations. For instance, an arbitrator may have a significant professional relationship with one of the parties or may have previously expressed opinions that suggest a predisposition toward a particular outcome. Even something as seemingly benign as social media interactions can sometimes be grounds for concern if they suggest a potential bias. The role of disclosure. As we discussed before, disclosure by the arbitrator is a critical part of this process. However, disclosure is only the first step. Once an arbitrator has disclosed a potential conflict of interest, the parties must decide whether to challenge their appointment. But here's where it gets complex. Not all disclosures lead to challenges. In many cases, parties may decide that the disclosed information does not pose a significant threat to the arbitrator's impartiality or independence. However, if a party believes that a disclosed fact does compromise the arbitrator's ability to remain impartial, they have the right to challenge the appointment. The process of challenge. So, how does one go about challenging an arbitrator? The process can vary significantly depending on the arbitration rules of the institution overseeing the dispute. In some cases, like the ICC or LCIA, the challenge is submitted to the arbitral tribunal and the other party, which then allows for the arbitrator to respond. However, some institutions, such as the ICDR, require that the challenge be submitted directly to the institution and the opposing party without notifying the arbitrator. Now, this is done to prevent any potential bias or retaliation by the arbitrator if the challenge is unsuccessful and they continue to serve on the tribunal. This variation underscores the importance of thoroughly reviewing the rules of the institution governing the arbitration. Understanding these rules can guide you through the correct procedural steps and ensure that your challenge is handled appropriately. Once the challenge is submitted, the institution or the tribunal must then review it. The process typically involves considering the grounds for the challenge, reviewing evidence, and sometimes hearing arguments from both sides. The institution or tribunal will then make a decision based on the relevant arbitration rules and the specifics of the case. If the challenge is successful, the arbitrator is removed and the replacement is appointed according to the procedure outlined in the arbitration agreement or the institution's rule. If the challenge is rejected, the arbitration proceeds with the original tribunal intact. Challenging an arbitrator is not a decision to be taken lightly. While it's a necessary tool for maintaining fairness, it can also delay proceedings and increase cost. Moreover, frequent or unfounded challenges can be seen as a tactic to disrupt the arbitration process, which could backfire. However, when justified, a challenge is crucial for preserving the integrity of the arbitration. If an arbitrator is genuinely biased or compromised, their continued involvement could lead to an unfair outcome, undermining the entire process. In conclusion, the challenge and removal of arbitrators is a vital mechanism for ensuring the fairness and integrity of arbitration. While it can be a complex and sensitive process, it is essential for maintaining the confidence of the parties and upholding the principles of justice that underpin arbitration. Well, thank you for joining me today. I hope this discussion has deepened your understanding of the challenge and removal process in arbitration. See you in the next episode.